Did you know Africa is ours to save? And did you know we cannot save Africa unless we talk about its problems? Talking about its problems mean proposing solutions to those problems. Thank you for watching the Beyond Africa podcast. We rely on you to grow and make this podcast better. Kindly keep comments in the comment section about the podcast. As such, we would learn from there and make the podcast more insightful, more educational, more entertaining, and more resourceful for the African continent. All we do here is advance the interest of Africa. Stay tuned and enjoy the rest of the conversation. Ladies and gentlemen, you're welcome to this edition of Beyond Africa. Today we fly all the way to Cameroon, where in October 2025, there is going to be a presidential elections with Cameroon's incumbent president, who has been in power since 1982, and he is about 92 years old. And rumors have it that he's going to contest at the elections. But you would be surprised. The contention is not about his age, it's not about the duration of his mandate. It is rather about the eligibility of one of Cameroon's main opposition candidates. And that is because this candidate and his party boycotted the 2018 municipal and legislative elections. One of those who have been championing conversations about this is Professor Maurice, who teaches at the University of Chang. He's a professor of law. We invite him here to give us a clearer view of why he thinks that the electoral code provision is unconstitutional and Maurice Kamto and his MRC party should contest at the upcoming elections. Prof, you're welcome to the Beyond Africa podcast.
Okay, thank you very much for the invitation. I want to greet all the web auditors, and I greet all those who will have to listen this podcast. It's a pleasure for me to share my ideas with you.
Thank you very much, Prof. As you all would know, Cameroon is a bilingual country, and we navigate between French and English, making it very special for us to have conversations of this nature. So Prof is going to explain to us what he thinks this time around in English, because he's been talking enormously to the Francophone population, and they already have that version of the conversation. But the Anglophone population is not yet well versed with these conversations. So we bring that to the English-speaking population and, of course, to the African diaspora. Prof, I don't know where you want to start from, but why do you think that a particular provision of the electoral code is unconstitutional?
Okay, I hope our web auditors are going to get my are following me very well, because as you said, my primary language is French, but I'm going to try to express myself in English, hoping that the message will pass. Before responding to your question, I want to make a precision. Actually, the debate is focused on Maurice Kamto, but you know, I think it's a strategy of the regime to avoid the attention on the candidacy of Mr. Biya himself, because in two of my videos, I proved that for the upcoming elections, Mr. Biya is no more eligible. I said it in two videos, and the grounds of this declaration are based on section 118 of the Electoral Code and 122 of the same Electoral Code. The section 118 provides that. I will read it in I will read it in French, but maybe I will give you an idea in English. In French, right. It is said, because I don't have the English version of the Electoral Code. I'm sorry. It is said in French. Sont inéligibles les personnes qui, de leur propre fait, se sont placées dans une situation de dépendance ou d'intelligence vis-à-vis d'une personne, d'une organisation ou d'une puissance étrangère ou d'un État étranger. If I can translate in English, it is said that are ineligible, that is, cannot be part of the competition. People who, by their personal facts, by their personal attitude, have placed themselves in a situation of dependence or intelligence vis-à-vis a person, an organization, or a foreign power or a foreign state. That is, I've tried to translate the content of the 118 section of the Electoral Code applied to Mr. Biya. We know that in 1990, Mr. Biya, being the head of a sovereign, of a so-said sovereign state, declared in Mondo Vision that he's the best student of François Mitterrand. You cannot be the leader of a sovereign state and declare yourself to be the student of another head of state. It means that by this declaration, Mr. Biya has annulled our independence, proving to the world that Cameroon is just a subdivision of France. That is Biya's declaration. And we remember that after the Grand Dialogue, National Grand Dialogue, he made a visit to France, where at the end of the visit, of a talk with Emmanuel Macron, he said that he has come to France to make a report of how the Grand Dialogue passed in Yaoundé. You cannot be a president of a sovereign state and you say you are going to make a report to another head of state. These two declarations, taken among many others that Mr. Biya has made during his 43 years of presidency, show that Mr. Biya cannot guarantee the sovereignty of our country. And according to this section 180 of the Electoral Code, it means that Mr. Biya can no more be eligible for the upcoming election. Okay. That is the first argument based.
Yeah, let's explore 118 first. Let me read it in English so the viewers would have.
Okay, thank you.
Yeah. So 118 sub 1 says, all persons who by their own doing have placed themselves in a situation of dependence or connivance with a foreign person, organization, or power or foreign state shall not be eligible. Ineligibility shall be established by the Constitutional Council within 3 days of referral to it at the behest of any concerned person or the legal department. So you said because President Paul Biya said he's the best student of Mitterrand, and he also said he went to give a report to France. Let us take the aspect of being a student of Mitterrand. Is that not saying that he is applying Mitterrand's philosophy, like another person would apply Jean-Jacques Rousseau's philosophy, John Rawls' philosophy, Karl Marx, or any other person's philosophy?
That's a very good question, because that's the objection that some of my colleagues opposed to this my declaration. No, it is not the same. It is not. It cannot have the same signification, because nowadays, if I say I'm a student of, let's say, Nelson Mandela, it means that my thoughts and my behavior are influenced by Mandela's ideology, Mandela's philosophy. And there is no way for Mandela to have an impact on me because Mandela has already passed away. So when you say that concerning a person who has already passed away, it just means that you have integrated his philosophy in your way of thinking, in your way of acting. The same, I could say I'm a student of Thomas Sankara, meaning that my way of thinking, my way of acting are influenced by the philosophy of Thomas Sankara. But when you say it in the presence of another person who is alive and who is in power, you see, it cannot have the same significance, because it means that it shows that being the president of a sovereign state, you submit yourself to another president. And we remember that Section 5 of our Constitution raises on the head of state the obligation to guarantee the sovereignty and the independence of the state. And you see, so by saying that in front of another president who is in power, it means that Mr. Biya was saying that he is ready to obey, to lie down. That is to submit himself to another head of state.
But
according to what we have just read,
the law says if you put yourself in a situation of dependence, Dependence
Yes.
here may mean something like taking up the nationality of another sovereign and another country, or deciding to use the passport of that country to do the public service or something. It's not the adoption of a philosophy.
No, those are some illustration of putting himself in a situation of dependence. That is, it can apply for you and me. That is, if for example, during our stay, you have taken, for example, a foreign nationality, it means that you have, but taking a nationality is not really the problem, because you can take the nationality of another state without putting yourself in a situation of dependence. Because the dependence
how would you
means that
define putting yourself in a condition of dependence? How would you define that?
No, it means that you abide to the authorities, or to the person, to the state, or the foreign power. That is, you abide. Just taking you can take the nationality, but if you want to contest for the presidential election, you renounce to that nationality. It means that you have broken any link with that state. But being a president in power and saying that towards another head of state, meaning that, because by obligation, according to Section 5 of our Constitution, it is the obligation of Mr. Biya to guarantee the sovereignty and the independence of our country. So he cannot, being in power, go and say, I am the best student of another head of state. It shows that the independence of Cameroon, the sovereignty of our country, means nothing for him. And these are facts that apply to this section 118, have as consequence to render Mr. Biya ineligible for the upcoming election. And he has reiterated this declaration recently, after the Grand Dialogue, when he went to France and said, I have come to make a report concerning a Grand Dialogue, whose object was to solve an internal problem. What was the concern of France to this Grand Dialogue? And he comes there, and in Mondo Vision, he says, I have come to report about the way the Grand Dialogue took place. No, those are signs of submission. And for a head of state of a sovereign country, it is inadmissible.
Let's assume he made that statement as a report to the United Nations. Would you have the same interpretation of submission?
It will not be the same, because the United Nations is in charge of providing peace, guaranteeing peace throughout the world. And since the Grand Dialogue was aimed at solving the Anglophone crisis, the United Nations were interested in knowing that peace is coming back in the country, because any point of the world where there is a threat to the peace, the United Nations is concerned. But what is the concern of France? No, the France cannot be the state where to give the report. It would be different if this report was made to United Nations. So that was only the first ground, section 118.
I have another question about that section 118. The section ends with saying that ineligibility shall be established by the Constitutional Council within 3 days of referral to it at the behest of any concerned person or the legal department.
Yes.
Let's keep away the legal department and talk about the concerned person. Is that term concerned person very clear to you? Who is a concerned person in this case?
Yes, it means that because for this section to apply, it supposes that Mr. Biya has, first of all, declared himself to be candidate. Because all these arguments that I'm developing will not apply if Mr. Biya retires. You see, if he retires, this argument will not hold. But if he says he will be candidate, that's where now this section becomes applicable. And any person, when this section talks of any interested person, it means that any candidate, because now we know that the whole electoral system of Cameroon is bad because of Mr. Biya. He's the one who has created all these people who are embarrassing the electoral system, and we are sure that if Mr. Biya retires, I think this person will not feel themselves as obliged as they are now. So any person who is candidate, who is challenging Mr. Biya, will be interested in raising this section in order to invalidate his candidacy. So when we talk of any person, it is anyone who intends to challenge for a presidential election. He's founded by this section to contest Mr. Biya's candidacy based on this section 118 of the Electoral Code.
Thank you very much, Prof, for that. Let us switch to section 122. Do you mind if I read from here?
Yes.
So 122 says the candidacy papers shall bear the following information: the full name, date, place of birth, occupation, and residence of the candidate, the color, emblem, and title for printing of ballot papers. The candidacy papers shall be accompanied by A, the list of the 300 signatures of dignitaries as required under section 121 and above, a certified copy of the candidate's birth certificate, the presentation and nomination of papers, a declaration whereby the candidate undertakes on honor to abide by the Constitution, a certificate of non-conviction, a tax or no tax certificate, a certificate of nationality, and the original copy of a certificate showing payment of the deposit. It shall be forbidden to use the colors green, red, and yellow. Why do you have an argument with that provision of the Electoral Code?
Okay, I want to draw the attention of our auditors on that declaration. Can you read that declaration again?
Which section?
That is the...
Which of the subsections?
No, of the section you have just read. That is
should I read all of it again?
Subsection 2. There is
Okay,
a declaration there, the declaration of honor by which the candidates engages to respect the Constitution. Can you read it again? That declaration, particularly.
So the candidate must submit, alongside all other documents, a declaration the candidate undertakes on honor to abide by the Constitution.
You see that is a declaration that any candidate must make. Applied to Mr. Biya. He has been in power for 43 years. And during his 43 years, we know that Mr. Biya has always violated our Constitution. So if Mr. Biya now wants to contest for the upcoming election and makes such a declaration cannot be fair. Because during his 43 years of mandate, Mr. Biya has always violated the Constitution. And if he makes such a declaration on an unfair ground, this declaration will only be considered as void because it is not a fair declaration. Let me just take some examples. You know that when the Constitution of 1996 was drawn up, it was clearly said that the limitation of mandates was an absolute clause which will not be modified by any other under any reason. But we know that in 2008, Mr. Biya modified the Constitution in order to lift this limitation of mandate. You see, it means that he has transformed our republic to a monarchy, violation of the republican form of our country. You see, because he amongst his engagement is to guarantee the respect of the Constitution. And the Constitution says that Cameroon is a republic, it's a democratic republic. So by transforming it to a monarchy, Mr. Biya has violated the form of our state. Secondly, when we turn now to the Declaration of Assets, Section 66 of the Constitution, Mr. Biya will be contesting for his 8th mandate. 8. During the 7th first mandate, has he ever declared his assets? Never. When we go now to the influence of Mr. Biya on the judiciary, being a democratic state, one of the pillars of democracy is the separation of the 3 powers, the legislative, the executive, and the judiciary. We know that Mr. Biya is the president of the Supreme Council of Magistracy. It means that he has confused the 2 of the 3 powers of the state, violating one of the pillars of democracy. So the transformation of provinces to regions, Section 55 of the Constitution, clearly makes the difference between provinces, which are administrative units, and the regions, which are decentralized entities, decentralized territorial collectivities. The Constitution makes that distinction. But in 2008, Mr. Biya took a decree fusing regions with provinces in violation of this distinction that the Constitution clearly made. If you take Section 53, it provides the putting in place of the High Court of Justice in order to try eventually the president and the ministers. This institution has never been placed, meaning that Mr. Biya has provided for himself a total immunity, because there is all. But when we know that the violation of the Constitution is constitute what we call in French the haute trahison, that is high treason. Okay, and when Mr. Biya does not respect the Constitution, he renders himself guilty of this high treason, and there is no court. The court provided to try him does not exist. So you see, these are many examples showing that the application of the respect of the Constitution has never been a concern of Mr. Biya. And applied to this Section 122, you see that the file of Mr. Biya cannot be valid, because this declaration not being fair according to all the violations of the Constitution that accumulated by Mr. Biya, his candidacy will not be acceptable. So that those are grounds. So people are focusing on Mr. Kamto, forgetting that Mr. Biya himself cannot contest for this upcoming election. And these are grounds. So these are the precision that I wanted to make before responding to your question. I don't know if you can go now to the question.
No, that's fine. The precisions are very important, and I just wanted to piggyback and talk about one or two things. The declaration is a declaration that looks forward. It doesn't look backwards. It says the candidate is making that declaration to respect the Constitution. So how would you apply a provision that looks forward on a declaration that had failed in the past? Shouldn't that have been raised during the current mandate?
No, for you and me, we cannot judge the fairness of the declaration, because we have never been in power. We have never been in a position where another person can appreciate our will to respect the Constitution. But for Mr. Biya, we have grounds to contest that his declaration cannot be fair. It is a void declaration.
Yeah, why don't you contest? Why don't you raise the issues in court now to say that he is not complying with the declaration that he made on his honor?
No, I say all these provisions that I'm citing, whether it is Section 118 or 122, they will apply only if Mr. Biya declares himself to be candidate. So you cannot raise it. So you cannot raise this. No, you cannot raise it now.
No, the declaration of
raise it only if Mr. Biya. Yes. You see?
The declaration of honor says that the candidate will make that declaration that during the mandate he is going to abide by the Constitution. So between the beginning of the mandate and the end of the mandate, he has to abide. So if he is not abiding, why don't you raise the arguments that, okay, you said you are going to abide, but you are not abiding, so you are in violation of the Electoral Code and the Constitution?
No, you cannot raise it now, because for the past mandates, he has violated the Constitution, but his file was already accepted, because he's now in power, according to the file he deposited in 2018. So this ground can be valid only for the upcoming election. So it presupposes that Mr. Biya declares himself candidate. And now, presenting his file, that's where his contestant will find the ground to contest his eligibility, because and they will base on the past mandates of Mr. Biya, which shows that the respect of the Constitution has never been a concern for him. He violates the Constitution at will, and this shows that for him, for you and me, no person will be able to raise the contest on our declaration, because we have never been in a position we have never been in a position to apply to respect the Constitution. It's not our duty, but for Mr. Biya, it is his duty according to Section 5 of the Constitution. So, since by the past he has never respected the Constitution, for him personally, it will mean that this declaration cannot be fair, and an unfair declaration is void. And the declaration being void means that Mr. Bia's file cannot be completed. That's law.
All right. Thank you very much, Prof, for this first part of the conversation. You touched on the amendment of the Constitution, but I don't see where the Constitution says that Section 6(2) of 1996 cannot be amended. Is that a particular provision that says that the mandate could not be amended?
No, the Constitution, the 1996 Constitution was the product of the tripartite the tripartite conference. And at the end of this tripartite conference, which gathered the regime in power, the opposition, and the civil society, there were some agreements. And it is in the agreements of which sanctioned the tripartite conference that this resolution was taken. That among the provisions of the Constitution that will never be modified will be the one limiting the number of mandates.
If you make an agreement, you don't write in the Constitution. That is not binding.
Yes, but in politics you have to show that you are a gentleman. You are a gentleman. There are gentleman agreements, and you have to show that you are a man of goodwill. If you take the resolution of the tripartite conference, you will find it there. But at the surprise of of any person, Mr. Bia in 2008 decided to lift that limitation of mandate. You see, it's not a fair person. He's not a fair person.
There are
because
arguments.
He betrayed the whole country. No, he betrayed the whole country.
Yeah, and there are arguments that Professor Maurice Kamto, is one of those who supported this modification of the Constitution in 2008. Why do you think that he would support it in 2008, if that is true, and then come to contest that support in 2025?
No, that is not true. Videos were shared on social media showing that this project was not even prepared at the Ministry of Justice. Remember that Mr. Kamto was Minister Delegate in the Ministry of Justice. So it was not even prepared at the Ministry of Justice, but at the Ministry of Territorial Administration, where the minister was Marafat Hamidou Yahya. And there are videos showing Mr. Marafat Hamidou Yahya defending this project. You know, there are many fake news in this country, but we are there to give evidence that these declarations are completely false. Mr. Kamto has never been associated in the preparation of this modification. It is a fake. It was prepared at the Ministry of Territorial Administration and defended in the Parliament by Mr. Marafa Hamidou Yahya. Mr. Marafa Hamidou Yahya says it. Describe how this project was prepared in his ministry, in a book. He has written a book. He has written a book. It is there. So people, in order to try to attack Mr. Kamto, are opposing him any idea that they have. It is not true. It is not true.
But he was working with the government at the time as the minister delegate. And is there any record of him opposing this constitutional amendment at the time?
But he will oppose on because of what? He was not in position to oppose. He was not already in the opposition. He was in the government. And even if he was against, what was his concern to raise an opposition in it? It was the responsibility of political parties who took part to the tripartite conference to raise an opposition to it. Mr. Kamto was not a part of the tripartite conference, and we know that when you have a convention, you can claim the benefit of the convention only if you are part of it. We say in French that les conventions n'ont d'effet quand les parties contractantes. Mr. Kamto was not part of the tripartite conference to raise an opposition against this proposition. But the parties who took part to the tripartite conference were still there, but none of them raised the contest against the proposition. Mr. Kamto had no quality, no capacity to raise an opposition against the proposition. We are in law, and in law you can only act when you are legally habilitated to do so. Mr. Kamto had no power to do so. It was the responsibility of the members of the civil society, the member of the opposition who took part to the tripartite party because they are the one who signed this resolution, and they were the only person well placed to claim the respect of this resolution, which was to bind the government, all the political parties, and the civil society.
Yeah, Prof. But Professor Kamto has been an academic who has been writing a lot on the Constitution of Cameroon. He's been very vocal on constitutional issues and electoral issues in Cameroon. And then he was member of government at the time. You just said politics is a game for gentlemen and of fair play. So if he felt that as an academic and as a critic and a constitutional scholar, that constitutional provision was being violated, why did he not, as a gentleman, as a man of fair play, critique it to the hearing of everybody at the time?
Mr. Kamto has published a book, a reference book on the constitutional law and political institution of Cameroon. If you read that book written by Mr. Kamto, I think maybe at the end of this broadcast, I will share the copy of the book with you.
Thank you.
It is clearly said in Mr. Kamto has constantly criticized the lifting of this limitation of mandates as an academician. Published a lot in constitutional law in Cameroon. I said the reference book on constitutional law in Cameroon is written by Kamto, and you will find a criticism on this modification in that book. He has written it clearly, so we cannot say that he has approved it. No, he was against because it is a pillar of any republic. When we talk of a republic, the republic must guarantee the possibility for all citizens to manage the public affairs. It is our right as Cameroonian. Any Cameroonian should have the possibility to manage public affairs. So when you lift up the limitation of mandates, you turn the republic in a monarchy. And that's what Mr. Biya has done. And that's one of the grounds why I am saying that Mr. Biya has always violated the Constitution, because the Constitution provides that our country is a republic, our country is a democracy. But by lifting this limitation of mandate, Mr. Biya had transformed our country in a monarchy, violating the form of our state as provided by the Constitution. You see, it is clear, it is law.
Thank you very much, Prof. That is quite interesting. Ladies and gentlemen, if you're just joining us now, we are watching the Beyond Africa podcast with me, Ngalim Bernard, and my guest, Professor Maurice Timchueng of the University of Chang. We are discussing Cameroon because in October this year, Cameroon is having presidential elections and critical conversations are going on about it. We implore you to like, subscribe, and share this conversation, especially because we are going to host more conversations about Cameroon, so you'll be informed when we have that conversation or the next episodes of the conversation coming up. So stay tuned. In the second part of this conversation, we are going to discuss the depth of Professor Maurice Timchueng's arguments against Section 121 of the Cameroon Electoral Code, why he thinks it is so, and why he thinks Professor Maurice Kamto should actually be a candidate at the elections, despite clear calls from other political parties that he does not qualify for the elections. Stay tuned as we come back. Did you know Africa is ours to save? And did you know we cannot save Africa unless we talk about its problems? Talking about its problems means proposing solutions to those problems. Thank you for watching the Beyond Africa podcast. We rely on you to grow and make this podcast better. Kindly keep comments in the comments section about the podcast. As such, we would learn from there and make the podcast more insightful, more educational, more entertaining, and more resourceful for the African continent. All we do here is advance the interest of Africa. Stay tuned and enjoy the rest of the conversation. Ladies and gentlemen, you're welcome back to the Beyond Africa podcast, where I'm having this conversation about elections in Cameroon with Professor Maurice Timchueng. And the second part of this conversation is going to focus on three critical issues that are going to be interwoven. The first is the relevance of legal arguments around these elections. The second is why Professor thinks that a certain provision of the Electoral Code is unconstitutional, and why the MRC acknowledged the impossibility of its candidacy in the 2025 elections, but now behaves as if they did not acknowledge that at the start. So, Prof, we've discussed an aside for over 40 minutes, and Now let's get into the crux of the matter. Why is the whole election about legal issues? Why is everything only about the law?
Yes, it is a strategy of distraction. When we talk of distraction, it means that the regime is creating all this polemic in order to avoid the Cameroonians to talk about the output of the 43 years of its catastrophic management. So it is creating these polemics everywhere to avoid any conversation on his output. But we are not distracted. We are focused. Well, as political parties are concerned, parties who can present their project only when the campaign is open. But for now, we have to reply to the strategy of the government, which is aiming at discouraging the citizens to go and register, because this massive registration of the citizen in the Elecam offices is threatening them. They are afraid of that because their potential electors are already over. They don't have any new electors again. So when people are going to register now, they know that these people are potentially supporters of the opposition. So in order to avoid that, they try to create this polemic, this doubt in their mind, saying that Mr. Kamto, who is the leader of the opposition now and who is in the heart of most Cameroonians, will not compete for the next presidential election. So it's a strategy, first of all, to distract the citizen in order to discourage them from registering massively on the electoral list, and secondly, also an accessory to try to lower down the contributions for Mr. Kamto's campaign. Because when the citizen knows that, doubts that Mr. Kamto may compete, he will not give his money, because people are giving the money to support Maurice Kamto. So it's a state strategy, first of all, to discourage the massive registration, and secondly, to frustrate this campaign of fundraising launched by Professor Maurice Kamto.
Professor Maurice Kamto and the MRSA put themselves in this situation by staying out of the 2018 municipal and legislative elections, and they did recognize the fact that they would not be eligible for these elections. So why do you want to put this at the foot of the current government and the CPDM?
No, I don't think, because the stone of controversy now is just one subsection of Section 121 of the Electoral Code.
Yeah, we are going to go into that, Prof. But when Professor Maurice Kamto was reading the decisions of the executive committee of the MRC on the eve of the elections in 2018, he said that he knows that this condition of this boycott of the elections is going to render the MRC ineligible for elections in 2025. He acknowledged it. His party acknowledged it at the time. Why did you give this easy playground to the ruling party?
No, the word of Mr. Kamto is not the electoral law in Cameroon. So Mr. Kamto, being a human being, can also mistake. Okay? Because by saying that, he has not modified the electoral law. And when we go now to the electoral law, we see that provisions will have not changed because of Kamto's declaration. And when we read now the section 122, I was coming to it, you will see that the first subsection provides that any person can be invested by any political party without any precision. It means that if you ground on this subsection 1, any legalized party in Cameroon can present a candidate. And CRM, being a legalized country, even at the period Mr. Kamto was saying that, could present a candidate on the basis of the subsection 1 of the of section 121. If you point, you can read it. So any political party in Cameroon can present a candidate on the ground of subsection 1 of the 121 electoral code. So the declaration of Kamto will not have as effect to annul this provision. It will always exist, and it is the provision that applies to govern the participation to the presidency. And according to this subsection 1, you can be presented either by any legalized party, and secondly, you can present yourself as independent candidate on condition that you gather 300 signatures among the 12,145 authorities cited by this provision. That is among municipal councillor, regional councillor, senators, and parliamentarians. The chiefs. Yes, we have made the point of this personality. There are 12,145 persons. That is, these persons can present at least 40 candidates, and they can present any citizen who expresses the will to manage the country. And Kamto, being a citizen, he doesn't lose his citizenship by declaring that. So after declaring that, he could lose that way. He could present himself as independent candidate. So this declaration has no value, as it does not modify the electoral law. It is not the word of the Kamto, of Professor Kamto, which makes the electoral law in Cameroon. When election comes, it is the laws that apply, not Kamto's words. So these two modalities will always apply to Professor Kamto. So when he was saying it was surely in relation with subsection 2 of this section 121, which provides that parties who don't have an elected, I don't know.
Yeah, an elected representative.
An elected representative, but they cannot directly present the candidate unless they gather the 300 signatures. Meaning that the interpretation of contrario means that parties who have elected representative can directly present a candidate. But I am saying that in my demonstration, I am saying that this subsection 2 cannot apply because it violates the Constitution. It violates the Constitution. If you want, I will develop my arguments.
Yeah, you are going to develop it in a moment. So you are saying that
yes,
following section 121 sub 1 and
yes,
sub 2, the MLC cannot present a candidate at the elections.
No, sub 2. That's the understanding of the regime. That's their understanding. But legally speaking, I am saying that this subsection 2 cannot apply.
So subsection 2, in other words, the second paragraph of subsection 2 means that it is the same thing with subsection 1. Is that what you're saying?
No. Subsection 1 does not submit the presentation of any party to the condition that they have any elected representative. Because subsection 1 says any candidate can be presented by any political party. Point. Okay? So subsection 1 does not precise the conditions. Subsection 2 says that the party must be represented in the municipal council and so on, for him to present directly a candidate without passing through the condition of the gathering of 300 signatures.
All right.
But I am saying that this subsection 2 cannot apply because it is unconstitutional.
But let's look at it this way. The MSA has recently had some elected representatives join them, because the law
yes,
says that parties that are not represented, it doesn't say that parties that are not having elected representatives. It just says parties are not
yes,
represented.
That are not.
Yeah.
A party is represented.
Yeah.
In municipal council, regional, it can present directly a candidate.
What is the legal definition of
contrary? According to what I know in law, I have finished my studies in law. There is no class in law that I have not met. According to what I know as definition of representation, representation means to sit in an instance on behalf of someone who is absent in order to defend his interest. That's the legal definition of representation. And when we take it in our current life, Ben, but when you say that Prof. Tim Chuen, go and represent me, it is based on confidence. That is what characterizes the representation, is a confidence between the represented and the representative. Okay, the person represented and the one representing him. Their relation is based on confidence, because you cannot be represented by someone with whom you are in conflict, because the representation is aimed at defending the interests of the person represented. So that is the definition in law. And when you understand representation like this, there is no debate to question whether a CRM is represented in municipal council or in municipal councils, at least.
But why would CRM be represented in municipal councils when we know that they did not contest the last elections?
Yes, just because the representation is not conditioned by the participation to an election. There is no definition of representation which binds it with the participation in electoral competition. There is no, you know, the person I'm going to tell you, Mr. My dear Ben, when we talk of the right to vote or the right to participate in the management of public affairs, which gives the right to any citizen to challenge for any political position. These two rights, right to vote and the right to manage the public affairs, are fundamental rights. When we talk of fundamental rights, we know the regime that goes with. When we talk of fundamental rights, according to Section 26, no, by definition, a fundamental right, it's a right which is recognized to any person. Because in their formulation, it is generally said, any person is entitled to, any person is. It means that in principle, the exercise of an electoral of a fundamental rights is not conditioned by anything. It's not submitted to any condition, because being a fundamental right, being a human right, any person is entitled to benefit from it. Now, according to Section 26 of our Constitution, if there can be any restriction in the exercise of a fundamental right, that restriction can result only from a legal provision. And when I talk of legal provision, it is law made by the parliament and promulgated by the head of state. It means that even the decree, even the arrêtés cannot restrict a fundamental right. So when you understand it, it means that any declaration, any argument tending at restricting the right to vote and the right to manage the public affairs will be based on a legal provision. That is the regime of a fundamental right. So those who are saying that to be represented means to have participated, they must use the legal basis of their declaration. So if there is no legal basis, it means that it's just distraction, as I was saying. It is only distraction. It is not a legal position, because treating of a fundamental right, any restriction can only result from an express legal provision, which does not exist.
All right.
When you read the Constitution, you read the Electoral Code, you will not find any provision defining representation in relation with the participation to previous elections. It does not exist. So that is distraction that the regime is organizing in order to make people think that Mr. Kamto will not compete for the upcoming election. It is just distraction. It's not law. It's not law. The same as you were basing on Kamto's declaration. Kamto's declaration is not the Cameroonian law. When the competition comes, it is the law that will apply. Yes.
Yeah. Let us read this contested provision this way. Had the law said a candidate nominated by a political party that did not nominate a candidate at the last elections, would you read this differently than using represented here?
Oh no, that's I think if it is the English version, the translation was not good.
I am trying to replace represented with not having invested a candidate, because there are two concepts here. One concept is represented means, in this context, represented means actually having a mandate in these instances. And
yes,
because there's an argument that says that represented means you should have nominated a candidate and contested the elections in order to have that representation. Now, if the law had said that you must have nominated a candidate without necessarily having representation, would your interpretation be the same or would it be different?
It will be different because in law there is a principle that when the law has wanted to say something, it must have said it. You understand me? We say in French, quand la loi a voulu dire, a voulu s'exprimer d'une certaine manière, elle l'a dit. But that's not what is said in our electoral code. Because even if the intention was to limit the number of candidacy for the presidency, they will have taken either, they will have provided a chapter either to define what would be understood by a party represented, or they will have said this straight in this subsection 2 of the section 121. But they didn't say it. They didn't say it. By not saying it, it means that the principle is that the right, which is concerned, which fundamental right, should be normally, naturally exercised by any person. There is no restriction. The restriction that will be valid are only those that are clearly affirmed by the law. But that one is just an opinion. And an opinion cannot have as effect to restrict a fundamental right. It is not admissible in law. Only a legal provision, that is a law adopted in the parliament and promulgated by the head of state, can limit the exercise of a fundamental right. And we are talking of the right to vote, the right to manage public affairs, which are fundamental rights. They can be restricted only by a legal provision, not by an individual opinion. So that's law. That's the nature. That's the nature and the legal status of a fundamental right.
Make me understand the difference between the limits on fundamental rights that you argue very strongly against in the context of citizens below the age of 21 not being eligible to vote. That is a fundamental right that is being limited.
Yes. No, the right to vote is a fundamental right. But as our constitution provides in section 26, the regime of fundamental rights will be precise by the law. And the law in question is the law on the electoral the electoral code, which has now opened the right to vote only to citizens who are aged at least 20 years, meaning that the enjoyment of the right to vote can be acquired by a citizen only if he reaches the minimum age of 20 years. So these are limitations contained in the law, as I was saying. So it is not a frustration of a human right, because according to the Constitution, if a fundamental right is normally recognized to any citizen, the law may precise the modality of enjoying it. So according to our electoral code, even the Constitution, because if you read, not even going up to the electoral code, if you read the Constitution section 2(3), section 2(3), it is clearly indicated there that the citizens that can participate to the vote are citizens aged at least 20 years. So it is not even the electoral code we have provided that.
Section 2
it is the Constitution.
Section 2(3) says the vote shall be equal and secret, and every citizen aged 20 years and above shall be entitled to vote. Then Article 3 says,
so you see.
Yeah, Article 3 says political parties and groups shall help the electorate in making voting decisions. They shall be bound to respect the principles of democracy, national sovereignty, and unity. Then it adds, they shall be formed and shall exercise their activities in accordance with the law. So the Constitution already gives room here for the electoral law to set in other limitations and other practicalities for its application. So do you still argue that this provision does not qualify to limit the right of a candidate to contest at the elections?
No. It is the Constitution which gives the power to the law to manage a particular situation. But by giving the mandate to the law, as you read in this section 3 or 6, when the Constitution has already made some provisions, the legislator cannot go above or beyond that. Concerning now the right to vote, as why I'm saying that this subsection 2 is unconstitutional. If you read now section 15 of the Constitution, section 15, it is clearly said in subsection 2 that the elected person represents not an individual, not a specific party, but the whole nation. Section 15 of the Constitution, if you have it, you can read subsection 2.
Section 15, subsection 2. Each member of the National Assembly shall represent the entire nation. The entire nation. So, by delegating the power to the law, the Constitution tells the law that you will manage the participation to the election, considering already that I have said that any parliamentarian must represent the whole nation. And not a political party.
The legislator cannot, not an individual, not a political party, or a fraction of the nation. It's not possible because the Constitution, which is above the law, has already decided that any elected parliamentarian represents the whole nation. So this subsection 2, which is in debate, has provided that the party must be represented. You see that it is in conflict with the Constitution, because according to the Constitution, there is no way, legally speaking, to say that a party is represented by an elected person. No, it goes against the Constitution. And that's why I'm saying that this subsection 2 is not applicable, because it violates the Constitution. The Constitution already made provisions on the matter of representation. So by regulating the electoral process, the legislator will avoid to contrary the Constitution on the points where he has already pronounced himself. And among these points, it is the extent of representation by any elected person already said by the Constitution. So the law cannot come later and say an elected person will represent a party. It is contrary to the Constitution. It is clear.
Yeah, thank you, Prof. So with this in mind, what can the MRC do? Can the MRC challenge this unconstitutional legal provision at the Constitutional Council before going in for the elections?
No, there is, according to our legal system, when a law is unconstitutional, after the promulgation of that law by the head of state, only some authorities are entitled to contest the constitutionality of this law. It is only the President of the Republic, the President of the Senate, the President of the National Assembly, 1/3 of parliamentarians, 1/3 of senators, and exceptionally the President of regional councils when the law affects the interests of their regions. So you see, it is very limited. We call it in French, le contrôle de constitutionnalité par voie d'action. That is the modality permitting a citizen to contest a law which violates the Constitution immediately after its promulgation. So this modality of contesting a law is very locked in Cameroon, but it is still possible when you are victim of this law. That is, when you are victim of an unconstitutional law, you can, during a court instance, raise what we call in French la question préalable de constitutionnalité. But if it is a normal court, it will block the matter for the judge now to send the matter to the Constitutional Court for him to pronounce himself on the constitutionality of this law. And if the Constitutional Court decides that this law is unconstitutional, it will not apply to you. So the effect of this modality of control is that it limits the extent of the unconstitutionality, because it does not counsel the law forever. It has an effect to avoid the application of this law to the victim who has raised the contest, and applied now to elections. It means that any party, as I've said, any legalized party now in Cameroon is entitled to present a candidate. Any legalized party. Now, if at the level of Elecam rejects the file on the ground of this subsection 2, any party, any candidate whose candidacy has been rejected can raise in front of the Constitutional Court the constitutionality of this subsection 2 of section 121. And as I've said, the unconstitutionality is evident. It is clearly evident. The Constitution has said an elected person represents the whole nation. The Electoral Code cannot say an elected person will represent only a party. It is unconstitutional. And by accepting the unconstitutionality of this subsection 2, it will not apply to all these parties or candidates. And finally, their file will be appreciated not in reference to subsection 2, but in reference to subsection 1, which provides that any person can be presented by any legalized party.
My understanding here is that you and the MSA are hoping and believing and trusting that the Constitutional Council and Elecam are going to interpret the law following the principles you have just discussed here.
Yes.
And you trust that they're going to do that.
The Constitution is the fundamental norm of a country, and it is the Constitution that gives the power to all those authorities. And according to the Constitution, even Elecam is supposed to carry out his duty in accordance with the Constitution and the law. It is said in their status that Elecam must carry out his duty in accordance with the Constitution and the law. So, from the moment where the Constitution has said that any elected person represents the whole nation, Elecam should take it into consideration, and it should avoid him to reject a candidacy on the ground of a legal provision which is contrary to the Constitution. But now, if Elecam does not respect the law, but I think there is a principle that the sovereignty belongs to the people. I think the people will now take its own responsibility to push Elecam to respect the provisions of the Constitution and the provisions of the law. It is not a matter of negotiation, because we are in a dictatorship. We are in a dictatorship. So it is possible that despite all these legal arguments, Elecam and the Constitutional Court refuses to acknowledge that this subsection 2 is unconstitutional. And if now they are determined to reject some candidacy, I think they are exposing our country to trouble, as we noticed it in Cote d'Ivoire. The crisis in Cote d'Ivoire came out just because there was an obsession of some people to reject, to prevent some people to participate in the electoral contest. You see, so the risk for our country is very high, and that's why we are communicating intensively to make Elecam and Constitutional Court authorities to understand that they have an historical responsibility to maintain the peace of our country by applying the rule of law. We are in a democracy, and one of the pillars of democracy is the authority of the rule of law. And when we talk about the rule of law, it is, according to the elections, it is these principles and text that I'm citing here. Thank you.
Thank you very much, Prof. For the interest of time, I don't know if you have any last words for the viewers.
No, I just want to tell Cameroonians, wherever they are, to believe that the transition will happen in Cameroon in October 2025. The transition will happen. We can no more support a regime that has failed in any domain after 43 years of management of our country. In 1982, when Mr. Biya took over the magistracy of our country, we were at the same position with China, Korea, Malaysia, and so on. Nowadays, we are among the very poor and indebted countries. You see? So the situation is very, very bad, and we cannot accept it. So we have to be ready to exercise all our constitutional rights for this regime to quit our country after October 2025. That's my last word.
Thank you very much, Professor Maurice Tim Chueng, for coming to the Beyond Africa podcast. Ladies and gentlemen, you've heard all. Stay tuned, subscribe, share.